Hello, my name is Kelly Legg, and today Ethics Committee Group 2 will be reviewing a case of physician impairment at University Hospital. After a review of the case, we will discuss relevant legal and ethical principles applicable to this case. We'll discuss the organization's reporting responsibilities. We will look at medical records considerations. We will review legal considerations pertaining to privilege, discovery, and work product. We'll discuss applicable codes of ethics and the consequences for noncompliance. And finally, we will provide ethics committee recommendations for this case and a conclusion. First, it's important to look at the stakeholders involved in the case. So there's the organization, University Hospital. There's the OR supervisor, Jan Adams. Operating room team, which included scrub nurse, circulating nurse, and anesthesiologist. Resident physician, or the physician in training, Dr. Truman. Dr. Spalding, the on-call trauma surgeon. And the patient, the 42-year-old trauma victim. At the end of the case, the media does become involved when they find out about what happened and reach out for. So it's important to understand the facts of the case for the ethics committee to perform its review. So in this case, a 42-year-old patient was seriously injured after a motor vehicle accident where they were struck head-on by a drunk driver going the wrong way on the interstate. They were airlifted to the hospital for emergency surgery. Dr. Truman, the resident, determined that surgery needed to be performed immediately to save the patient's life. The OR staff tried repeatedly to reach Dr. Spalding for 3 hours, but he was unreachable. The backup surgeon was never contacted. After 3 hours, Dr. Spalding arrived, but smelled of alcohol and was visibly drunk. The OR supervisor recommended he not join the surgery and moved him to the doctor's lounge. The resident completed the surgery. They removed the spleen and repaired the liver, and surgery was a success. This was saving the patient's life. The following day, the OR supervisor was contacted by leadership about a call from a local reporter who had learned about the physician impairment and wanted a comment. The hospital must respond publicly. There are some key themes present in this case that make it something that the ethics committee needs to review. There's patient safety and rights, physician impairment, the process of emergency decision-making, resident supervision, the organization's responsibility when there's impaired surgeons and responsibility for reporting, potential legal liability, and the responsibility to the community. Next, we're going to look at some legal and ethical principles that apply to this case.
Hello, my name is Bridget Mosley. We will begin by examining the informed consent requirements for surgery and how those requirements change when a patient is unconscious during a medical emergency. We will first explain the usual elements of informed consent, and then apply the emergency consent exception to the university hospital case. Under ordinary circumstances, surgery should not proceed until the informed consent has been obtained. Informed consent requires more than obtaining a patient's signature. The patient must have decision-making capacity, act voluntarily, and receive enough information to make an informed choice. The physician should explain the nature and purpose of the surgery, its material risk and expected benefits, reasonable alternatives, and the likely consequences of refusing treatment. The patient should also have an opportunity to ask questions before agreeing. Consent for surgery should normally be documented in the medical record and signed by the patient or a legally authorized representative. A general consent signed during admission does not replace the procedure-specific consent required for an operation. Failure to obtain valid consent may expose the physician and hospital to malpractice or battery claims, especially when treatment exceeds the permission given by the patient. An emergency creates a limited exception to the usual informed consent requirements. When a patient is unconscious or otherwise incapable of deciding, the law generally recognizes implied consent if immediate treatment is necessary to prevent death or serious harm and there's not enough time to locate an authorized surrogate. The assumption is that a reasonable person would consent to urgently needed life-saving care. This exception does not give clinicians unlimited authority. Treatment should be limited to what is reasonably necessary to address the emergency. The team should check for an available surrogate or advance directive when time permits, and should respect any known refusal of treatment. The physician must document the patient's incapacity, the urgent condition, why delay was unsafe, efforts to identify a surrogate, and the treatment performed. Once the emergency ends, consent must be obtained for additional non-emergency care. The emergency exception clearly applies to the university hospital patient. He arrived unconscious with deteriorating vital signs and severe internal bleeding that require immediate surgery. Because delaying treatment to obtain consent likely would have resulted in death, implied emergency consent legally supported Dr. Truman's decision to begin life-saving treatment. However, emergency consent addressed only the patient's inability to provide authorization. It did not excuse the absence of attending physician supervision, the failure to contact the second on-call surgeon, or the failure to follow established escalation procedures. These separate breakdowns increase the hospital's legal, ethical, and patient safety risks. Perry emphasizes that patient safety must take priority over personal loyalty, and the hospital policies must be applied consistently. Several managerial actions were needed. The hospital should implement a standardized emergency consent checklist, audit emergency surgery documentation and chain of command escalation, reinforce physician coverage and emergency response policies, and provide ongoing staff education on emergency consent and reporting requirements. These actions would improve documentation, strengthen accountability, and help prevent similar failures in future emergencies. With the consent requirements established, we will next examine patient rights, patient safety, and guidelines for managing disruptive physician behavior.
Hello, everyone. My name is Patrice McNeil, and today I will be discussing the following laws: patient rights, patient safety, and disruptive physician behavior. The events at University Hospital demonstrate how patient rights can be jeopardized when concerns about provider impairment are not addressed promptly. Dr. Spaulding's intoxication affected his ability to safely contribute to patient care, and Jane's hesitation to report the issue allowed the risk to persist. Patients have the right to receive care from healthcare professionals who are fully capable of performing their responsibilities both physically and mentally. The Patient Self-Determination Act supports the principle that patients should be informed in their health care whenever it is possible. By failing to immediately report the situation and arrange for an alternative physician, the hospital did not adequately safeguard the patient's rights. Healthcare organizations have both ethical and legal obligations to ensure that all patients receive care from qualified and competent providers, regardless of a clinician's position, reputation, and status within the organization. The next law we will be discussing is patient safety. Patient Safety and the Quality Improvement Act. The PSQIA promotes a culture of safety in which healthcare professionals are encouraged to report errors, near misses, and unsafe conditions without fear of retaliation. In the University Hospital case, Jaya recognized that Dr. Spaulding was impaired when he arrived at the operating room intoxicated. There had been previous concerns about Dr. Spaulding's alcohol use while on the job. However, there were never any formal complaints made. Since there were no reports made, now the patient's care has been jeopardized. By maintaining open communication and encouraging staff to report concerns without fear of repercussion, the PSQIA helps healthcare institutions learn from incidents and strengthens safeguards designed to protect patients from future preventable errors. The final law that we will discuss will be disruptive physician behavior, which is part of the Joint Commission standard. The university hospital case illustrates the dangers of failing to address disruptive and impaired physician behavior. Dr. Spaulding's intoxication compromised his ability to safely fulfill his responsibilities as an attending physician, which is a breach of professional responsibility. Jane's decision to privately manage the situation rather than formally report it allowed a known safety concern to persist. The Joint Commission standards encourages organizations to respond promptly to such incidents through reporting, investigation, and corrective action.
Good day, everyone. I am Favor Magdalene Lansana, and I will be talking about two laws in regards to the case. One is medical negligency. Medical negligency will occur when a healthcare professional breaches the acceptable standard of care and that results in any injury to the patient. Now, for that to occur, there are four established medical malpractice elements. One should be the duty of care, breach of duty, causation, and damages. Now, in this case, the standard of care by reporting to work intoxicated, and Jane Addams failed to follow hospital policy, not only activating the second on-call surgeon or reporting to the physician impediment, increased the patient's risk of harm. And the law number 2, which is corporate and vicarious liability. Now, corporate and vicarious liability allowed a healthcare organization to be held liable, responsible for a negligence act committed by the employee acting within the scope of their employment. Corporate negligence further holds hospitals directly responsible for failing to maintain safe system, enforcing policy, proven competent staff, and adequate supervision patients' care. Because the university failed to enforce physician impairment policy and allow breakdown in supervision and escalated procedure, the organization may face both corporate negligence and vicarious liability. Now, in this case specifically, the case demonstrates both individual and corporate liability. The doctor failed to meet the professional standard of care by arriving at the hospital intoxicated, whilst Jane Addams failed to follow established hospital procedures for physician impediment and emergency escalation. The failure exposed the patient to preventable risks and increased the hospital potential legal liability. Beyond the action of the individual involved, the hospital may also be held responsible because a system failed to ensure corporate supervision, enforce physician impairment policy, and activate the backup surgeon when the attendee physician was unavailable. From an ethical standpoint, accountability, professionalism, integrity, organizational responsibility require immediate intervention to protect the patient because healthcare professionals should and try their hardest to prevent any damage from happening. The case illustrates that healthcare organizations must not only establish safety policy, but also consistently enforce them to reduce legal exposure and maintain public trust. Thank you for your
Stand for the Emergency Medical Treatment and Labor Act, and it was enacted in 1986 as part of the Consolidated Omnibus Budget Reconciliation Act, also known as COBRA. We also know that EMTALA is codified under Federal Law Act 42, United States Code Section 1395 DD, and is implemented through the regulation found in 42 Code of Federal Regulation Section and 489.20 and 489.24. The purpose of EMTALA was to address the problem of patient dumping, which occurs when hospitals deny emergency treatment or transfer patients because they lack insurance or could not afford care. Now I'm going to speak about the brief description of EMTALA. EMTALA require medical care participating hospital with emergency department to provide emergency medical care to anyone seeking treatment regardless of their insurance status, citizenship, or ability to pay. It means that the law ensures that emergency care decisions are based on a patient medical condition rather than financial consideration. You can also say that EMTALA serves as an important patient protection law because it guarantees access to emergency services for vulnerable population and individuals facing financial hardship. Concerning the EMTALA hospital obligation, EMTALA imposes three major obligations on hospital. First is the medical screening examination, commonly referred to as an MSE. Hospital must perform an appropriate medical screening examination to determine whether an emergency medical condition exists. The second is stabilizing treatment. It means that if an emergency condition is identified, the hospital must provide treatment necessary to stabilize the patient before discharge or before the patient will be transferred to another hospital. And third is appropriate transfer. Patient may only be transferred if the benefit outweigh the risks. The receiving hospital agree to accept the patient and appropriate transportation arrangements have been. These requirements are intended to protect patients from harm and ensure continuity of emergency care. EMTALA also establishes responsibility for physicians who participate in emergency call coverage. Hospital must maintain on-call roster of specialists who are available to provide service needed to stabilize patients with emergency medical condition. On-call physicians are expected to respond within a reasonable time frame when contacted by the emergency department. They may be required to come to the hospital to evaluate the patient, participate in treatment decision, and assist in stabilizing patient before transfer. And if the physician failure to respond appropriately may constitute an EMTALA violation and may result in penalty for both the physician and the hospital. Concerning EMTALA violation and penalty, violation of EMTALA can have serious consequences. Hospital may face civil monetary penalty, increased regulatory scrutiny, federal investigation, and even termination for Medicaid participation. Physicians who fail to fulfill their on-call responsibility may also be subject to censure. In addition to financial penalty, EMTALA violation can damage an organization, reputation, and increase legal liability. Because of these risks, healthcare organizations must develop policy and procedure to ensure compliance with EMTALA requirements. Requirements has also have ethical principles. We start with beneficence. The first ethical principle associated with EMTALA is beneficence, because it refers to acting is the best welfare of patient and promoting their well-being. EMTALA support beneficence by ensuring that individuals receive emergency treatment regardless of their financial circumstances. Healthcare professionals have an ethical obligation to provide care that improve patient health and protect patient welfare. The second ethical principle is justice. Justice focus on fairness and equal access to healthcare services. EMTALA embodies justice because it guarantees that emergency medical treatment is available to everyone regardless of socioeconomic status, insurance coverage, race, ability to pay. This principle help reduce healthcare disparity and promote health equity. The last one that I'm going to talk here is ethical principle non-maleficence, because it means that avoiding harm to patient. EMTALA supports this ethical principle by requiring hospital to stabilize patients before transferring them to another facility. Without stabilization requirement, patients could experience worsening condition, delay in treatment, or preventable injury. EMTALA help ensure that patients receive appropriate emergency care before being discharged or transferred. The AIMA Code of Ethics also aligns with EMTALA requirements. AIMA emphasizes patient advocacy, equitable treatment, confidentiality, and accurate health information management.
Hello, my name is Sharmil Lacoste. This section of our presentation highlights three important components of healthcare quality and patient safety reporting. First, we'll talk about the Healthcare Quality Improvement Act. Next, Patient Safety Quality Improvement Act. And we'll end with the National Practitioner Data Bank. The Healthcare Quality Improvement Act, or HCQIA, was enacted in 1986 to improve the quality of healthcare by encouraging hospitals, medical professionals to participate in peer review with the fear of unnecessary lawsuits. The law also requires certain disciplinary action against healthcare providers to be reported to the National Practitioner Data Bank. Next, we will discuss the Patient Safety Quality Improvement Act, or PSQIA. The PSQIA was passed in 2005 to improve patient safety by encouraging healthcare organizations to voluntarily report medical errors and patient safety events. The law also protects this information from being used in legal proceedings, allowing providers to identify problems, learn from mistakes, and implement safer practices. Finally, let us review the National Practitioner Data Bank mentioned above. The National Practitioner Data Bank, or NPDB, is a confidential national database that collects information on medical malpractice payments and adverse actions involving healthcare professionals. Hospitals, licensing boards, and other authorized organizations use the NPDB during credentialing and hiring decisions to help ensure patient. Now that we have learned about the Healthcare Quality Act and the Patient Safety Quality Act, let us discuss why the National Practitioner Data Bank is important. Reporting to the NPDB is required when medical malpractice actions are taken against healthcare providers, clinical privileges are suspended or restricted for more than 30 days, professional licenses are suspended, revoked, or restricted, or hospitals or licensing board take other reportable disciplinary actions. Together, these laws promote accountability, protect patients, improve healthcare quality, and ensure that the healthcare organization make informed decisions when hiring and granting privileges. Please allow me to introduce Tracy, who will discuss the HIPAA Privacy Rule Medical Record Act.
Hello, my name is Tracy Osekelo, and I'm going to give presentation on Section 8 of the HIPAA Privacy Rule, Medical Record Access. The Health Insurance HIPAA Privacy Rule. HIPAA stands for Health Insurance Portability and Accountability Act, enacted in 1996, also known as HIPAA. HIPAA provides national standards to protect patient rights, and protect health information of patients. HIPAA allows covered entities to use or disclose patient information without authorization of treatment, payment, and healthcare operations. This role is defined as 45C.F.R.164.506. Healthcare operations include quality improvement, competency, medical credentialing, peer review. The minimum, everybody needs to have access based on their responsibilities. For example, like if you work in administration, there's no need for you to have access to patient information because it doesn't really affect your job as much compared to somebody who is a nurse or a doctor. They really need access to such information as they need to provide direct care to a patient. In this case, we have a CEO that requested access to medical records, and per HIPAA violation, that will be a HIPAA violation because the CEO does not automatically deserve access to medical records because they don't really affect their role in one way or the other. They don't provide direct patient care, and unless the medical records are going to be used to their administration responsibilities, the CEO does not need access to patient medical records. And other ways that a CEO might need access to patient records maybe will be through risk management, compliance, oversight. If there's a lawsuit and they need to go through patient records to see if they are at fault or not, and they can acquire to get information like for the medical records. The CEO will be required to uphold HIPAA minimum necessary standards when accessing patient records. Members of the peer review committee for medical staff can review medical records as long as it's purpose for healthcare operations. Yes, and then the next part will be and then in my last slide, key takeaways from this case study is that there are several ethical principles that have been applied to this case. We have confidentiality, which is protecting patient privacy, autonomy, respecting patient rights, promoting healthcare through beneficency, preventing unnecessary harm from non-maleficency, and justice, applying privacy laws equally. The key takeaway from this case study is HIPAA balances privacy and healthcare operations. The CEO access must be job related unless he's doing risk management, compliance, or there's a lawsuit directly associated to the access directly to the hospital. And then we have peer review supports quality improvement, and PH access must comply with federal laws and ethical standards.
Hello, my name is Sam Honore, and I will be discussing privileges, discovery, and work product as they relate to the university hospital physician impairment case. Specifically, I will cover what medical records could be released or shared, how they should be shared, when redaction and privilege apply to limit release, and when the attorney work product doctrine excludes materials from discovery. What can be released? The scope of discovery. Discovery rules define what a party can obtain from the opposing side once litigation begins, and Maryland's rule permits discovery of anything relevant that is not privileged. The patient's clinical record easily meets that relevance standard, since it documents exactly what happened in the operating room. Physician-patient privilege does exist in many states, including protections built into Maryland practice, but it is a creature of statute rather than a universal common law rule, and it is not absolute. Once a patient's medical condition becomes the subject of the lawsuit, as it would in any claim arising from this surgery, courts generally treat the privilege as waived for records related to that condition. What remains outside the scope of discovery is anything covered by attorney-client privilege or attorney work product, which are addressed in the next 2 slides. How records should be released, court orders, and subpoenas. Not every legal demand for records is treated the same way under HIPAA, and getting this distinction right matters. A court order signed by a judge must simply be complied with, limited to what the order specifically authorizes. A subpoena signed by an attorney is different. The hospital cannot release anything until it has assurance that the patient was notified and had a chance to object, or that a productive order is already in place. Shaw 2020 frames this as a step-by-step process. First, confirm the authority behind the request. Then, confirm its exact scope, and only then check whether any of the records requested carry extra legal protection before producing anything. In our case, that means health information management and hospital counsel, not the OR staff who lived through the incident, should be the ones handling any request for the patient's record, confirming at each step that the hospital is releasing exactly what the law requires and nothing more. Redaction and privileges that limit release. Redaction and privilege work together to keep a record's release from becoming broader than the law allows. Shaw 2020 makes the point that a broad request for the entire medical record does not reach categories the law singles out for extra protection, and mental health, substance use, and psychotherapy information are the clearest examples. That protection is especially strong for substance use disorder treatment records. Federal regulations require a separate, specific court order before those records can be disclosed at all, and an ordinary subpoena is not enough. This is directly relevant to Dr. Spaulding. If the hospital refers him to a physician health program, that records that program generates about his evaluation and treatment would fall under this heightened protection, separate and apart from the medical record of the patient he treated. Attorney-client privilege provides a second independent layer of protection. It shields what hospital administration tells counsel and what counsel advises in return. So the hospital's internal deliberations about how to respond to the reporter stay confidential even as the underlying facts of the case become public. Work product exclusion from discovery. Work product is easy to confuse with attorney-client privilege, but the two protect different things. Attorney-client privilege only covers communications with an attorney. Work product can cover documents prepared by anyone, an administrator, a risk manager, an outside consultant, as long as they were prepared for the attorney or at the attorney's direction because litigation was anticipated. The key trigger, as the 10 Things blog emphasizes, is that the material has to be motivated by anticipated litigation specifically, not created as part of the hospital's routine operations. Once hospital counsel gets involved because of the reporter's inquiry, any investigation or analysis counsel directs for that specific purpose can be protected work product. What is never protected, no matter who is asking or why, are the objective facts that were already documented in the medical record before anyone anticipated a lawsuit: the vital signs, the medications given, and the timeline of the surgery itself. Ethical principles around privileges, discovery, and work product. These protections only serve their purpose if they are applied consistently. Justice means the heightened protection for substance use disorder treatment records applies to Dr. Spaulding exactly as it would to any other physician who sought help for the same condition. The law is not more protective of him because of his position, nor less. Confidentiality is the operational side of that principle. It falls to health information management and clinical staff to make sure PHI and any privileged material stay out of circulation except through the legal pathways just described. And non-maleficence is the reminder that mishandling any of this, releasing more than a subpoena authorizes, or releasing SUD treatment records without the specific court order the law requires is not a paperwork error. It is a source of real harm to the people involved, from the patient whose privacy is at stake to Dr. Spalding, whose path back to safe practice depends in part on those records staying protected.
Hello, my name is Kayla Moore, and I will be discussing the professional codes of ethics and legal consequences. So the first professional code that applies here is the AMA Code of Medical Ethics, specifically Opinion 9.031. This code establishes that physicians have an ethical obligation to report impaired colleagues in accordance with their state's legal requirements. It is not optional or just a suggestion, it's a defined professional duty. So how was this code actually violated in our case? There are two physicians whose conducts fall short here. First, Dr. Truman, he completed the surgery without ever reporting Dr. Spalding's impairment to the residency program director. Now, we recognize there's a real power imbalance at play. Residents depend on attendings for evaluations, references, and future job opportunities. So speaking up against respected attending can genuinely be difficult, but that imbalance doesn't erase the ethical duty the AMA code places on him. Second, and most directly, Dr. Spalding himself violated the code by simply showing up to operate while intoxicated. And this wasn't an isolated lapse. Jane had noticed a pattern here before. Multiple prior instances with no escalation meant the warning signs were there and were repeatedly ignored. The second code we're applying is the ANA Code of Ethics for Nurses, specifically Provisions 3 and 3.5. And this one is central to Jane Addams' role in the case. Provision 3 establishes that the nurse's core responsibility is to promote, advocate for, and protect the rights, health, and safety of the patient. That's the foundation of everything else is built on. Provision 3.5 goes further and specifically addresses impairment. Nurses are required to identify and report signs of impaired practice in their colleagues. Now let's look at how Jane's actions fell short of this code. She never reported the recurring pattern. This wasn't the first time Dr. Spalding had arrived smelling of alcohol and she let it slide before. On the night of the incident itself, when his impairment was unmistakable, her response was to walk him to the doctor's lounge to get him coffee rather than notifying anyone up the chain of command. The core issue is that her highest duty under the ANA code was always supposed to be to the patient, not to protect the colleague she liked and respected. However, well-intentioned, that protection was felt in the moment. Before we move into other legal and ethical issues our group identified, I want to highlight two additional federal laws that classmates research for their own sections because they connect directly to this case. First, the HIPAA privacy rule. HIPAA sets national standards protecting patients' protected health information, but it does allow disclosure without authorization for healthcare operations like peer review and physician credentialing under the minimum necessarily standard. Second, and I think even more directly related to our case, is the Emergency Medical Treatment in Labor Act. This requires hospitals to provide a medical screening and stabilizing treatment for emergency patients, and it specifically requires on-call physicians to respond within a reasonable time frame and show up when needed. Dr. Spalding, as the on-call surgeon, took almost 3 hours to respond to Jane's call. That's not just a violation of internal hospital policy, it's a potential compliance failure, which creates a separate and serious layer of legal exposure for the hospital. And going back to HIPAA for a moment, if the university hospital convenes a peer review committee to look into Dr. Spalding's conduct, that's a legally permitted use of medical record, but access still has to be limited to what's actually necessary, protecting the privacy of everyone, including Dr. Spalding himself. Now let's talk about what happens if this case is not resolved, starting with the legal consequences. The hospital faces real malpractice liability on two fronts: direct negligence for failing to enforce its own on-call and impairment policies, and vicarious liability for the conduct of Jan and Dr. Truman as its employees acting within scope of their duties. There's also a forward-looking risk if the hospital applies inconsistent discipline in this case versus future incidents. That inconsistency itself becomes a liability because it can be used to show how the hospital doesn't apply its own policies fairly. Beyond the legal risk, there are unethical and organizational consequences that are just as serious if this goes unaddressed. First, the culture of the OR itself is damaged. Staff learn the rules are conditional, applied differently depending on who you are and who the supervisor happens to like. That kind of inconsistency erodes trust in leadership and lowers the bar for everyone's conduct. Second, without intervention, Dr. Spaulding's underlying substance use disorder will likely get worse, not better. Research shows that untreated SUDS in physicians typically progress to a loss of clinical competency over time. So inaction isn't neutral, it's actually harmful to him as well as his patients. And finally, the surgical residency program's accreditation remains genuinely at risk until the hospital can show it took real corrective action, which has financial and reputational implications for the whole institution, not just the individuals that are involved. Now we will discuss recommendations and manager actions.
My name is Bobby Makins. After reviewing the facts of this case, the Ethics Committee concludes that the hospital must address both the individual actions of the healthcare professionals involved and the organizational systems that allow the incident to occur. First, Dr. Spaulding should be immediately removed from clinical duties pending a comprehensive fitness for duty evaluation and referral to an appropriate physician health program. At the same time, the hospital should initiate a formal peer review and credentialing investigation to determine whether additional disciplinary action or reporting requirements apply. Equally important, University Hospital should conduct a comprehensive root cause analysis to determine why established safeguards failed. The committee found that breakdowns occurred in communication, supervision, escalation procedures, and compliance with hospital policy. Leadership should specifically evaluate why repeated concerns regarding physician impairment were not reported and why the second on-call surgeon was never contacted. From a health information technology perspective, the hospital should ensure that all documentation related to the event is timely, accurate, objective, and securely maintained with the electronic health record. Consistent with the HIPAA security rule, leadership should perform a security risk analysis to evaluate vulnerabilities involving electronic protected health information, access controls, audit logs, and clinical documentation workflows. Routine audits should verify that only authorized personnel access patient records throughout the investigation and that disclosures remain compliant with HIPAA's minimum necessary standard. Finally, the committee recommends strengthening the organization's compliance program by implementing recurring HIPAA privacy and security training, cybersecurity awareness education, physician impairment reporting education, and routine compliance audits. Continuous quality improvement initiatives should monitor physician response times, reporting compliance, documentation accuracy, and patient safety indicators. These management actions create a culture of accountability while reducing legal, ethical, and operational risk. Throughout this presentation, we have examined legal, ethical, and regulatory issues surrounding physician impairment. As the Ethics Committee, our recommendation is clear. Protecting patients requires more than responding to a single event. It requires a culture of accountability, strong leadership, effective health information technology governance, and continuous quality improvement. By implementing these recommendations, University Hospital can reduce future risks, strengthen compliance, and restore public trust. Thank you all for your attention. We now be happy to answer any questions that you may have about our presentation. there are no further questions, here are our references. Thank you.